The case of justice seems gargantuan and a virtue when people demanding it were seen as mere commodities just 3 centuries back. Anonymous. The day of August 18, 1619, brought with it a peculiar journal entry, by today's standards, in the form of 20 and odd Angolans being kidnapped, fairly transported, by the Portuguese, who arrived in the British-occupied colony of Virginia, who were later resold to the English colonists. While this will cater to shake some folks today, it was an essential and common trading practice back in the day. Human civilization has been around for more than 2 million years, but the essence of humanity hasn't really gotten along on track. This is quite evident in the fact that some groups of people are forced to spend a life of misery and injustice, citing the color of their skin as the primary cause. The date and tale of the enslaved Africans have now become symbolic of the infamous transatlantic slave trade that flourished during the 1500s and beyond. This tussle would divide a great part of the United States in the American Civil War. The infamous racist legacy of the slave trade saw surging movements thereafter in the form of the Montgomery bus boycott, the American Civil Rights Movement, resistance against the racist Jim Crow laws, movements against hateful lynchings, modern-day incarceration, and disproportionate imprisonment of Black people to the present-day Black Lives Matter movement. Awareness has definitely flourished in mainstream media regarding the cause. But what goes on at the root level of jurisdiction? What happens when a Black voice is raised to demand justice and fair judicial representation? They are still put down to rest. That is the bitter truth. What you see on a 16:9 television screen is a minimal portion of what really goes around in the real world. Judicial conduct and the procedure have had a bad reputation for being extremely slow and rigid. This increases tenfold when the person seeking justice happens to be Black. Presumptions have taken such a hold that they are seen as culprits, even when they are innocent. Today we take a dive into the issue of judicial misconduct against Black people, and we'll try to create a framework for its prevention in the future. The definition of judicial misconduct is pretty straightforward, but its implications are frightening. It refers to a serious and malleable deviation from the usual and accepted practices involving the pursuit of justice during a trial or any other judicial process altogether. This segregation can take several forms, and they are as follows. Law agencies using their office for special treatment for friends and relatives, accepting bribes and personal favors, thus completely banishing the fair nature that must be the cornerstone of this system, engaging in diabolical political activity that favors one side, violation of rules and standards meant to protect the interests of the victims, engaging in sexual, abusive, and offensive behavior, intentional discrimination on the basis of sex, gender, sexual orientation, religion, race, and color. The focus must be zoomed in on the last 2 factors mentioned in the previous point, race and color. Racial segregation and bias have always plagued law enforcement agencies from the very core to the highest segments it has to offer. These bold claims are backed by statistics that make us nod our heads a little harder and reflect and force us to think about how humanity can stoop to a level where the color of your skin can bar you from getting justice and a fair share of representation in society. Here are some numbers for you. More than half of death row exonerees are from the Black community. Out of a total of 185 people who have met this fate since 1973, about 53% of people are from the Black community alone. This data is verified by the Death Penalty Information Center. The irony to this matter is that the states who have awarded the most penalties also happen to be the states where cases of lynchings of Black victims have been maximum. Nearly half the people currently on death row are Black. If data from some decades back reflects inertia, let's talk about the modern context. In the year 2020, about 43% of people on death row were Black, though Black people just constitute 13% of the entire US population. Sounds strange enough, right? It sounds unfair for sure. Innocent Black citizens are 7 times more likely to be wrongfully convicted of murder in comparison to white citizens. When the mindset of society frames someone wrong based on color, long before the actual flawed justice system steps in, it makes it even more prevalent than the ill nature which goes around is out of bounds. According to the National Registry of Exonerations, among Black people exonerated from murder convictions, around 31% were wrongly convicted for a crime they never committed, purely based on their skin color. Police misconduct in cases involving Black people, the wave that shook the world on May 25, 2020, when a 46-year-old Black man by the name of George Floyd was murdered by an officer named Derek Chauvin of the Minneapolis State Police Department. According to the National Registry of Exonerations, cases of Black people exonerated from wrongful murder convictions were 23% more likely to face violence by sanctioned police authorities and departments alike. This proves that racial bias can play a role in wrongful conviction cases even before it steps into the courtroom. About 1/3 of unarmed citizens to be killed by police are from the Black community, according to Mapping Police Violence. In 2017, out of 149 armed people killed by the police, 49 were Black. The population ratio once again pops in with serious question in this regard. Judicial misconduct brings down the core fabric of what is necessary for a working and robust judiciary system. The judiciary cannot exist without the trust and faith of the citizens. Targeting one particular section hampers the organization and can bring about negative consequences. Rulings must be passed by competent, lawful, and independent judicial officers. As former United States President Theodore Roosevelt once said, "No man is above the law, and no man is below it, nor do we ask any man's permission when we ask him to obey it. Obedience to the law is demanded as a right, not asked as a favor." Judges presented with the task of administering law must be ethical in cases of any individual, no matter what their color and other features are. They must do what is right. With this hope, we move forward to take a structured look at slavery, public segregation, and modern-day bias to understand the core issue in a better way. Stay tuned for the next segment. Some people believe that libertarians only have their interests rooted in taxes and regulations. But without a doubt, the most important libertarian accomplishment in history has to be the abolition of slavery. While talking and surfing through some facts in the previous episode, we as a civilized class are forced to think about how someone can proclaim that all men are created equal, endowed by their Creator with certain unalienable rights. When a huge proportion of men, women, and children alike are captured in the chains of bondage, segregation, and discrimination that dates back to a couple of centuries prior. And the sad part is, it still continues to dominate the domain. In this episode, we'll take a closer look at what has become of the Black community from the infamous age of colonialism to the modern day. The Renaissance brought about a technological revolution in the field of transportation, which enabled the less reliable ships of the Middle Ages to withstand and counter the long journeys across vast oceans for trade. The outcome of this technological advancement was the discovery of a sea route towards the continent of North America by voyager Christopher Columbus in 1498. Do you know that slavery as a practice had been in place for a long time in Europe, dating back to the days of the Roman Empire, through various wars, incarceration, bondage, and criminal punishment? But we must note that the enslavement of the African population did not begin commercially until the discovery of the Americas in 1498. and by the passing of an edict in the year 1518. In August 1518, King Charles I passed an edict that authorized Spanish traders to enslave people directly from Africa and transport them to America to work on their plantations. This mandate was diabolically important in the sense that it enabled the wicked colonists to increase the number of enslaved people that were brought to the Americas, as the necessity of going through a European port was no longer required. Free market monopoly, they say. The case with America was that the European explorers were busy in their colonization by setting up humongous plantations of profitable items, including sugar, cotton, and tobacco. The huge labor needed to work on these plantations would be satisfied by the influx in various batches of slaves coming in from Africa. Before this scenario, the Europeans enslaved the native populations of a particular colonized area to do manual labor in the plantations, as was the case in the Caribbean. Soon, a combination of pathetic working conditions and disease brought from Europe began to take its toll on the natives. At times, entire populations were wiped out. Can you imagine the horrors inflicted on these poor souls who were already under the harsh whip of their white masters, and now they had to face this? This cycle of labor and death made these colonists turn their attention entirely to Africa for slaves, and the slave trade began in its entirety. It must be noted that the Portuguese were the first to have completed the first recorded transatlantic slave voyage, when they transported enslaved Africans to their colonies in Brazil in the year 1526. Soon other Europeans would follow the same. And so was their fate sealed for the coming 300 years. Europeans started to build their notorious way to the western coast of Africa to trade slaves as a means of cheap labor for their plantations. Soon vast numbers of people from the black community, as well as other natives, were being captured all across the massive continent of Africa. They were brutally chained together so they could not escape and were forced to march to the coast, where they were literally packed like commodities for further transportation. They were sold to European slave traders, put onto ships, and taken across the Atlantic. Conditions on board the slave ships were very harsh, as they didn't have enough light, air, food, water, or any basic necessity. They were not allowed to move about. As many as 1/3 of their total quantity died on the ship itself during the 8-week journey. The ones who unfortunately did survive were often separated from their families and sold to different slave owners at slave auctions to the highest bidder. Africans from different cultures who spoke different languages were loaded together so that their uncommon ground in communication could lead to a better working process. Confused? This was so because they could not understand each other, preventing them from making plans to escape, a literal play of divide and rule. If we say that enslaved people faced a hard life on the plantations, where the work was heavy and the hours were long, this would merely be an understatement. Their accommodation was grim, and they were often fed meager amounts of food that even animals would gladly ignore. The majority of them were also whipped, beaten, and incarcerated for the smallest mistakes, and soon died after arriving on the plantations. Even the strongest rarely survived for more than 10 years, and very few ever saw their homeland again. The slave trade reached its unholy peak in the 18th century, when approximately 6 to 7 million people were shipped from Africa to America. It is quite natural that this devastatingly impacted traditional African societies, destroying entire kingdoms, while others grew rich and rose to power in the trade. From the 1780s, however, some Europeans began to come to terms with how cruel slavery was and started campaigning against it. Preachers of morality rise up at last. How ironic. This can be attributed to the spread of a concept and philosophy called humanism during the phase of Enlightenment, or in historical terms, the Age of Enlightenment in the late 18th century. It advocated that all men are created free and equal and the ownership of fellow men for whatever reasons are acts of evil. In the British Empire, Member of Parliament William Wilberforce took the baton to pass an act in the British Parliament that would lead to abolishing slavery. On 22nd February 1807, the House of Commons passed a motion which was 283 votes to 16 to abolish the Atlantic slave trade. Hence, the slave trade was abolished in official terms, but not the still economically viable institution of slavery itself, which provided Britain's most lucrative import at the time, sugar. Abolitionists did not move against sugar and slavery itself until after the sugar industry went into its terminal decline after 1823. Regardless, the British Navy took some initiative when it formed its own squadrons to hunt down slave ships operating within its territorial waters. Between 1807 and 1860, the Royal Navy squadrons seized about 1,600 slave ships and freed an estimated 150,000 Africans. The diabolical benefits and expansion of the Industrial Revolution had rendered the need for mass labor redundant in certain industries. This was the main economic reason for the move to end slavery, while the political reasons were many. Machines were now employed in areas where humans were crunched in together. This shows the value of a life in comparison to a monetary benefit. So much so for the word humanism. If we consider the French Revolution earlier, 1789, then this resistance to slavery had spread to its colonies in Haiti, where a full-scale rebellion between 1791 and 1801 had freed the country from colonial rule. Fearing similar rebellions in their own colonies, other European powers had made overtures toward the abolition of slavery. Talking in the American context, the United States saw the issue of abolition of slavery as the culmination of the American Civil War from 1861 to 1865. Fought between an anti-slavery North and a pro-slavery South, the war ended in a Northern victory that saw the complete abolition of slavery in the continental United States under the presidency of Abraham Lincoln. Slavery in other regions of the Atlantic still continued, especially in the Spanish and Portuguese colonies of South America and the Caribbean into the late 1860s. Even when British enforcement and further diplomacy finally ended the Atlantic slave trade. In 1870, Portugal ended the last trade route with the Americans, and the last country to import slaves was Brazil. In Brazil, however, slavery was not finished until 1888, making it the last country in the Americas to end involuntary servitude. As the case always remains, official numbers have always rendered us from the ground reality of how things operate. On paper, the cruel activity was reduced to a bare minimum, but in the coming age, a new form of colonialism called neocolonialism took shape, and if not directly, continued the segregation of the Black population. In order to fully comprehend the present-day bias, it was necessary to dive deep into the issue of how these people have been treated in the past. Legacy never fades. In the coming segments, we'll discuss legendary figures in the Black rights movements and their consequent connection to law, the same variant of law that has taken this historical bias into the modern age. If we look at the most important of Martin Luther King Jr.'s contributions to American history, then his commentaries on the relationship between law and social justice would find their place in the forefront of things. His views towards the law can be divided into two broad categories: law as an obstacle and law as an opportunity. This comes naturally as the core of the civil rights movement was a struggle against the very foundation of law, against racially discriminatory laws or racially neutral laws that segregationists used to attack civil rights activism in the previous decade and widely used in the past to shut down inhabitants from the Black community. We already have several instances when Southern police arrested civil rights protesters, including, on multiple occasions, King, for violating practically every criminal code provision, like disturbing the peace, marching without a permit, violating picketing or boycott laws, trespassing, engaging in criminal libel and conspiracy. Provisions from the law have been historically misrepresented to undermine a just cause. The question is on you. Where do all these provisions hide when a common black man is fatally assaulted in broad daylight? As said before, misconduct starts way before the matter enters the court of law. This was proved when the NAACP, or the National Association for the Advancement of Colored People, was prosecuted in Alabama and elsewhere for refusing to disclose its membership rolls as required by state law. Additionally, several southern states went after civil rights attorneys for legal ethics violations. Montgomery used minor traffic ordinance violations as a way to undermine the carpools used during the iconic Montgomery bus boycotts. The state of Alabama also prosecuted King on charges of supposed tax evasion. When you can't stop the revolution from rising, bring in the sections. It is widely noted that King often found difficulty in gaining moral ground in his explanations as to why civil rights activists were justified in breaking certain unjust laws. He tackled this question in his 1963 letter from Birmingham jail, where he differentiated between just and unjust laws. A just law, he explained, is a man-made code that squares with the moral law or the law of God. An unjust law is a code that is out of harmony with the moral law. Since segregation laws falls squarely in the latter category, I can urge men to obey the 1954 decision of the Supreme Court because it is morally right. And I can urge them to disobey segregation ordinances because they are morally wrong. This construct explains why certain paths must be embarked upon to challenge the existing regime and fight for something more than just a cause, the true spirit of humanism. This doesn't necessarily make someone a criminal. To question the legitimacy of specific laws can be seen as a baby step in the correct direction. King continued by stating a more difficult situation that involves a law that is just on its face and unjust in its application. The same kind of law landed King in his Birmingham jail cell since he had been arrested for parading without a permit. This shows how even the most just causes are hindered and paralyzed by the book of the law. Now, there is nothing wrong with an ordinance which requires a permit for a parade, he explained. But when the ordinance is used to preserve segregation and to deny citizens the First Amendment privilege of peaceful assembly and peaceful protest, then it becomes unjust. In this case, King might have won in the court of public opinion and certainly in the court of history, but he lost in the land's highest court. This statement makes so much sense considering that he is revered even today. This wasn't enough, though. Even though the Supreme Court finally decided to hear an appeal of the conviction of civil rights protesters for violating a state court injunction ordering them to refrain from demonstrating, the court ruled 5-4 against the civil rights protesters, resulting in a big shock. On usual occasions, King and his colleagues generally fared well before the Supreme Court, but this case was one of a handful of exceptions. Justice Stewart, writing for the court, reprimanded the protesters in the case now known as Walker versus Birmingham. This court cannot hold that the petitioners were constitutionally free to ignore all the procedures of the law and carry their battle to the streets. That was exactly the need of the hour, to shed old feathers and take them to the streets. People may argue if this was the correct way, but then we must be reminded that what good has come from the normal and lengthy procedures of law. Injustice and misconduct don't only hide under the garb of unjust decisions, but also in the forms of delay injustice, which at times may be consequential and deliberate. In a case as grand as this, we have to sympathize with the petitioners' impatient commitment to their cause. However, respect for the judicial process is a small price to pay for the civilizing hand of law, which alone can give abiding meaning to constitutional freedom. After all, this happened to the demand from the very get-go, and for our protagonist in the form of King, unjust laws and the courts that enforced them were the real obstacles in the cause of racial justice. If we look back at events in a continuation, we realize how law and justice could have been used in a better and just manner at every junction of social and political history. There were a set of laws that King and other civil rights activists wanted. Pretty straight and simple. School desegregation orders, non-discrimination requirements for restaurants, hotels, and private employers, voting rights protections. King had a peculiar understanding of court decisions and legal reform as a central component of broader political and social struggle. He certainly saw the importance of courtroom decisions and legislation, but when he talked about the power of law, he focused on how to take up the difficult work to give life to basic legal principles. According to him, judicial and legislative breakthroughs were not just moments for celebration, they were calls to action for a broader social change. His tense relationship with civil rights lawyers helped shape his attitude toward the law. From the very beginning of his civil rights career, he recognized his debt and goodwill to civil rights lawyers. This was pretty evident when in December 1955, on the eve of the Montgomery bus boycott that first brought him to the nation's attention, he gave a speech in which he framed boycotters as buildings on the long work for civil rights lawyers, particularly the dramatic NAACP victory in Brown versus Board of Education case the year before. He focused on bringing every component together in his fight for racial equality. "If we are wrong," he declared, "the Supreme Court of this nation is wrong. If we are wrong, the Constitution of the United States is wrong. If we are wrong, God Almighty is wrong." In addition, civil rights lawyers also played a critical role in the eventual triumph of the boycott. The boycott was almost on the brink of failure and faced a potentially crippling legal challenge to the motor pool system on which the boycotters relied. Then the news arrived that the Supreme Court had struck down the segregated bus system as unconstitutional, which would have taken away the source of transportation for the boycotters. Amidst the chaos, the role played by civil rights lawyers was very prominent. Even after all this, King sought to distance himself from the NAACP and its litigation-based tactics. This was due to an element of inter-organizational rivalry at play. King's SCLC, Southern Christian Leadership Conference, established in 1957 to coordinate the action of local protest groups throughout the southern states of America, competed with the NAACP for attention and funds. With this also came the mode and nature of action, which resulted in an element of a generational divide at play, as King became more closely aligned with the younger frame of the movement that was committed to direct action protest and was pretty much against the legalistic tactics favored by the older civil rights activists. This sounds familiar to India's case with extremists and moderates in the case of the Revolution for Independence. King stressed that the work of lawyers was important, but at the same time also cautioned that this must only partially dominate the energy of the movement. If we look closely, the direct action protest was both an extension of and an alternative to the NAACP's project of school desegregation litigation, which by the late 1950s had largely turned ineffective as several obstructionist legal maneuverings greeted it. The work was destined to be very slow with this path. And so, a new wave of civil rights protests emerged, sparked by the student lunch counter-protests of 1960 and largely motivated by frustration with the slowness of legal reforms and their unjust nature to the Black community. To put forward and make people understand what drove African Americans to take to the streets to demand their rights, King explained, "One must understand the pendulum swing between the elation that arose when the school desegregation edict was handed down and the despair that followed the failure to bring it to life." He meant that the standard law procedure was prolonged and failed to create any significant ground impact. Frustration towards these proceedings was evident, not just among the Black community, but also among other participating races. He critiqued what he saw as an overly idealistic vision of the law that the NAACP lawyers relied upon in making their case for Brown. When the United States Supreme Court handed down its historic desegregation decision in 1954, many of us, perhaps naively, thought that great and sweeping school integration would ensue. Injustice might find its expression in unjust laws, but King added further and said that the roots of injustice are deeper. For King, the law by itself, in its whole shape, was limited in its ability to affect hearts and minds, and in the ultimate pursuit to uproot disgruntled patterns of inequality, everyone must acknowledge the limits of legal reform. King emphasized that African Americans must not get involved in legalism and needless fights in lower courts, for that was exactly what the white man wants the Negro to do. Then he can draw out the fight. This was the harsh lesson learned from many legal battles. With massive resistance, he announced, "Our job now is implementation. We must move on to mass action in every community in the South, keeping in mind that civil disobedience to local laws is civil obedience to national laws." King's contribution to the struggle for racial equality was his passionate skepticism towards the effectiveness of legal change when the element of organized social action was missing. This inaction will not compensate for the long-fought battles on the ground. They are destined to fail every time they enter the courtroom. In this episode, we discussed King's underrated vision for this cause. The majority of people are well aware of his contributions to the American civil rights movement, in theory and on paper, but very few are aware of the contractions and methods required to stitch a weary battle as this one. In the coming segment, we'll listen to how the unconscious bias plays a role in judicial proceedings. Stay tuned for more. You must have heard the saying that the first impression is the last impression. This proves to be true in many circumstances that pertain to meeting people and connecting them in personal and professional relationships, just to cite a condition. We tend to look at a person and frame their entire history, personality, and definite future with the help of a few qualities. While this remains out of danger when the situation is social, what if this tendency is also applied to a place as important, crucial, and life-altering as a court of law? Can justice really be delivered on account of factors that are highly personal and visible to the naked eye? Will a constructive analysis of events and the case not prove much more beneficial? If your answer is yes, congratulations! You have officially deleted some sense of bias that the Black community faces every day. Let's see how. Unconscious bias tends to be applied by our brains, resulting in the making of incredibly quick judgments and assessments of people and situations. Your unconscious brain processes information 200,000 times faster than your conscious mind. Psychologists call them the reacting brain and observing brains, respectively. The brain looks for patterns, and it influences your behavior whether you like it or not. And the interesting thing is that sometimes the person in charge is not even aware of what is happening. With a range of studies and experiments, scientists estimate that at any given point, we are exposed to as many as 11 million pieces of information. However, our brain can only functionally deal with about 40. It is important to know that we are all the victims of bias to some extent in every decision we make. To put it more officially, being biased refers to having a tendency, inclination, or prejudice either in favor or against something, someone, some group, or some organization. It is worth nothing that these areas of bias can lead to unlawful discrimination based on alignment to race, gender, or gender identity, ethnicity, or migration status, religion, weight, height or age, union association, family responsibility or pregnancy, sexual orientation, marital or relationship status, disability, or physical appearance. Multiple studies have shown that every person, whether they like it or not, has implicit or explicit biases. And when these biases enter the criminal justice system, they can often hamper and compromise the outcomes of court cases that particularly at times have people's lives on the line, sometimes literally. On paper, the criminal justice system promises a fair and impartial trial for all. However, this promise is rarely fulfilled on the ground level, and its wide application is highly questionable. In a system where all checks against implicit biases involve asking people whether or not they have them, there is much room for biases to creep into courts unchecked and not regulated by any specific psychological backing. This results in situations where diverse voices are not heard in meetings and courtrooms, significantly where decisions can be impaired, and usually the consequences are harsher than imagined. This is a major stain on the reliability of the law system and society as a whole, and is bonded in the courtroom or any other varied workplace. The three musketeers in this regard are assumptions, stereotypes, and contextual information, and they have the utmost ability to influence any judgment, sometimes unintentionally, but the results can be devastating. Studies also show that this impacts the decisions of forensic experts, witnesses, and mock jurors alike. Majority of the people are already unaware of their cognitive biases, and so they become very hard to regulate. But their impact can be mitigated, or in the wider sense of things, improved by a variety of targeting strategies. Let's have a look at some of them. The two major pillars in fighting this are self-awareness and acknowledgement, and that too on a daily basis. Occasional analysis and morality cannot help us, and we need to accept that. It's not about just committing to the issue, it's based on its comprehensive implementation. For example, if we view a person who comes from the Black community in the sense that they are always up to something shady, then we are normalizing a huge bracket of the population under the umbrella of a mistake made by a certain individual at any given moment. The same can be applied to white men as well. It is not necessary that they are always innocent and far away from the shady streets of crime. But the thing to keep in mind is, don't assume. We need to engage our conscious brain to interrupt biases. That means we need to question ourselves thoroughly, and others as well, and to be well aware of the fact that tackling our unconscious biases takes the impenetrable trio of intention, attention, and time. With this, we all can, at an individual and collective level, take steps to be more inclusive colleagues and leaders to make better and fairer decisions. Before judging anyone, one must examine their own behavior to help challenge the norms and try exposing themselves to something different. Commit to at least one individual action. The good news is that it is never too late to come out and change. Remember, when you point a finger at someone, the remaining fingers are pointed toward you. The need to call out and question in a polite, comprehensive, and constructive manner has to be done when something or someone is trapped in an unconscious bias. In addition to this, celebrate the individuals who do the same. Figuring out, pointing out, and inculcating positive values in institutional figures such as training judges, barristers, police, and other associated groups on bias and educating jurors may reduce the influence of cognitive biases in court. This can be more effective if the process is continuous and embedded into politics that impact people on the ground level. As discussed before, this practice should not be a one-off or even a few sessions. Otherwise, this will not work. Exposure to certain groups, auditing, and procedural changes, such as adding another judge, must be initiated. Increasing juror diversity and adding jury instructions can be a way to make the judicial process more fair and inclusive. We will highlight this issue in a broader sense in the coming episodes. The primary solution to a problem is to recognize that there is a problem in the first place. It must be followed with honest discussions about bias. These discussions may be uncomfortable but necessary to create a positive and effective change in and out of the courtroom. Bias has a gradual but harmful effect in the courtroom just because of the sheer number of existing biases in addition to their target groups. An efficient way to counter the ill impact of biases can be implemented if we could somehow blind jurors and judges to the defendant without blinding them to the evidence. With this, only absolute facts will be presented and used in the judgment, potentially shutting down a huge area for bias. This will be complemented by no visual cues to trigger potential biases against appearances and markers such as gender, race, accents, affiliations, etc. It is important to note that while judges themselves do not decide guilty or innocent in a jury trial based on their preconceived notions, they have the power to decide what sentence a defendant receives. Sounds interesting, right? Facts and studies have shown that judges in both the UK and the US serve Black defendants with longer prison sentences than white males in similar circumstances. The same applies to gender, where male defendants are given longer prison sentences than female defendants despite similar offenses and criminal history. Judicial misconduct doesn't escape the realms of gender and sex at any point. To support these claims, we need to note Shadow Secretary of State of Foreign, Commonwealth, and Development Affairs David Lammy's report, which was published in the highly acclaimed Lammy Review over 4 years ago in September 2017. It stated, "The racial bias in our justice system is creating a social time bomb. 41% of under 18s in custody are from minority backgrounds, compared with 25% a decade ago. Young Black people are now 9 times more likely to be in youth custody than young white people. These are alarming concerns and prove that bias is creeping deeper into our law agencies and system alike." The University of Bedfordshire conducted a comprehensive study that estimated that children in the care system are 7 times more likely to be subject to imprisonment during childhood than those who are not in care. It is an open secret that the prison population in England and Wales is disproportionately made of individuals who have been in care at some time in their lives. 5 brownie points to those for guessing from which ethnic group this proportion is maximum. Some reports have also shown that people of minority ethnic backgrounds are overrepresented within the criminal justice system in England and Wales. It is quite natural that the Black Lives Matter movement and its worldwide protests in 2020 were further fueled by these types of long-standing inequalities within the criminal justice system. The courtroom, for many, acts as a place where microaggressions are spent. These are subtle behaviors that affect members of marginalized groups. They can, however, add up in the long run and create even greater conflicts over time. This can be attributed as part to hostile communication and opposing viewpoints, which can appear as banter and over-discrimination and harassment, but in reality are acute indicators that the system is not healthy for people from varied backgrounds. These examples are not limited to defendants in the courtroom, but extend to staff and barristers from diverse backgrounds. For example, diverse barristers have been mistaken for defendants in the courtroom and cleaners within their chambers due to implicit and unconscious bias for a prolonged period. We have now noted that race does matter in the criminal justice system, whether we like it or not. Black defendants appear to fare worse than similarly situated white defendants. Why? Implicit bias is to blame. Researchers have used a well-known measure called the Implicit Association Test, IAT, and have found that most white Americans harbor an uneven and dangerous bias toward Black Americans. Do judges who are professionally committed to egalitarian norms hold these same implicit biases? This seems true in practice, but modifications can surely be done. We must hope for a better system by implementing cases and critiques. This is not new that the usual courtroom mechanism requires modernization and transformation in order to eliminate unconscious bias. This is possible with persistence and commitment to ensure true equality and justice. And most importantly, bravery and courage are required for this change to occur in and out of the courtroom. The burning question remains, will each of us, as individuals and responsible citizens of the land, be part of the solution and act today? Coming up, we'll discuss the George Floyd case in detail and link it with police brutality, forcing us to ask an essential question. Does misconduct start and take its form even when the case doesn't actually reach the courtroom? Stay tuned for the answers. At times, you get to hear a kind of news or witness an event as brutal as the violent death of George Floyd in Minneapolis on May 25, 2020. After this heinous event, demonstrations and riots against police brutality started in numerous cities of the United States under the banner of Black Lives Matter, which demanded a thorough reform of law enforcement and a crackdown on police brutality. Multiple reports examined factors of police brutality and discrimination related to the incident. In spite of this, we, as a collective unit, are still falling short in developing a comprehensive framework to undo the complexity of the events that followed adequately. The big question that arises here is that amongst hundreds of similar cases annually, what makes the George Floyd incident exceptionally prone to motivate collective social actions of such scale, and why a wide-scale revolution took place? If we apply the method of collective action theory, we argue for a detailed interpretation of the emerging circumstances, accounting for both traditional conflict theoretical perspectives as well as the individual, highly situated characteristics of the focal incident, with a special attention towards the COVID-19 pandemic as not only social, but also psychological, economical, and political context. In simple words, this means that the collective consciousness of the people is tired from within and is looking for better alternatives that can be concrete, answerable, and have reliability. A lack of such a system results in the segregation of ethnic and racial minorities, even before they can present their case in a court of law. And what happens next has been asserted in this discussion before. According to the results of an expert investigation, his death was caused by heart failure and pressure on his neck. Following the event, demonstrations and riots against police violence held under the banner of Black Lives Matter started in numerous cities in the United States. This later went on to cover multiple countries, such as the United Kingdom, Germany, and Denmark. The radicalization of the event connected to the George Floyd case is definitely not justified by the fact that a person was killed because of police violence. If we compare these stats with other Western democracies, then a thing that pops up is that the measures taken up by the US police officers while arresting an accused are more likely to result in a lethal outcome. They are brutal in plain terms. In fact, the annual number of lethal use of firearms or law enforcement measures by the police, if taken as a ratio per million citizens, is significantly higher in the US, 2.9, when compared to, for instance, Canada, 0.7, Germany, 0.1, or the United Kingdom, 0.04, resulting in an average of 930 casualties per year. In contrast, the same number is 25 in Canada, 8 in Germany, and only 2 in the UK. Statistics cannot lie, can they? A report published in 2015 stated, "Police in England, where modern policing and many American cultural and legal traditions originated, are rarely compelled to use deadly force. US police forces killed more people in the first 24 days of 2015 than British and Welsh police have killed in the last 24 years. Some figures suggest that in the course of over 25 years between the years 1980 to 2005, as many as 9,500 people lost their lives due to police action in the United States. Adding to this, numerous deaths marked the beginning of 2010 and beyond, which also received publicity like Eric Garner, John Crawford, Michael Brown, Tanisha Anderson, etc. Considering the above, the question arises as to why the events of 25th May 2020 led to social incidents with such serious consequences and broad international impact. Even so, mapping the totality of causal relationships, in this case, would be an exercise reaching way beyond the scope of this study. However, we seek to identify the most significant social, political, economic, and law enforcement factors that were most likely to have influenced these occurrences. To understand the motivations behind this movement, one must analyze the behaviorist theory of collective action in a way that it holds some sort of social phenomena, such as panic, mass hysteria, strikes, demonstrations, or even some social movements. Black Lives Matter can be considered one of these, and how they only appear to be different. But the reality is that all these movements, which are out of sync, involve collective action and are rooted in the same logic. A fire rises when people have had enough, and that has always been the case. Take any other social revolution, and the similarities will be crystal clear. It is widely stated that movements such as these have this quality. At the same time, these forms of collective action indicate the abnormal functioning of the social system, occur as an outcome of social tension or disturbance. In a way, it can be said that the collective actions, such as demonstrations and riots, are very much the litmus test of the background of social tensions. However, the processes and aspects behind these tensions can be extremely heterogeneous and varied. We saw in the previous episode that Martin Luther King Jr., despite being one of the forefront figures in the civil rights movement, never forgot to repair the elements that were fighting even on his side. He realized the problems with normal jurisdiction and its processes and how they impacted the overall deliverance of social revolutions and justice before the world united for George Floyd. However, the methodologies involved then and now are heterogeneous, as said, but move in the same path and spirit. In this episode, based on the relevant sources, we will try to examine the factors that could have contributed to the breaking point and escalation of open and mass protests against the police and its practices, including police brutality, following the misconduct that led to the death of George Floyd. Our first source of attention will be the theoretical perspectives on policing and its associated discrimination. Following this, we need to examine the incidents' individual characteristics and look into the things that led to the basis for collective action and of this magnitude. This will be complemented with special attention towards the pandemic and its social, health-related, political, and economic consequences and factors leading to the criminal escalation of events. In law enforcement, a direct and pure form of discrimination is called racial profiling. A report published in 2012 described it as, "This form of discrimination is founded on the mistaken presumption that there is a correlation between ethnic, racial, religious, or national minority status and criminal behavior." Researchers were quick to trace these cases of discrimination against various ethnic minorities by the police as early as the 1990s. A relevant result of the profiling analysis was that even the sight of a police vehicle or patrol car creates a defensive attitude in members of the minority group, and the possibility of interaction with a police officer creates anxiety and tension. And so the interaction between the inhabitants and the forces is not entirely neutral. There's always an associated shady area related to this, a probability that something bad will happen if the conversation escalates. Thus, police action in a negative context may easily result in a conflict between the participants. These long-term frustrations paint the entire force with doubt and contribute to the general distrust between the police and the concerned citizens. George Floyd was an African-American citizen. In this case, the masses' criticism is often targeted at the discriminative behavior of certain members of the police force. One of the stated reasons for the mass protests after the event was also the statistically proven numbers, which show that the risk of death resulting directly from police violence is extremely high among non-white citizens. A report published based on survey data between 2009 and 2012 found that the rate of police action with a lethal outcome was 2.8 times higher amongst African Americans than for white citizens, thrice the usual rate. Additionally, the majority 83% of people who died due to police action were armed, but the thing which faces scrutiny is the number of unarmed casualties among African Americans, 14.8%, than among unarmed whites, 9.4%, or even Hispanic Americans, 5.8%. Between 2013 to 2019, African American citizens were 3.23 times more likely to lose their lives due to police brutality in comparison to their white counterparts. Robert Rayner, in his paper, The Politics of the Police, found that the police officers are more prejudiced than the community environments in which they serve, and this is nothing but the prejudice of the society at large in which we live and thrive, a reflection of the general bias of mainstream society. According to Gifford's Law Center to Prevent Gun Violence, multiple studies suggest that the lack of confidence in the police is an important factor because it is one of the motives behind armed violence in the major U.S. urban and semi-urban centers. Robert Warden cites that the extremely high rate of violent behavior may reinforce the image of the opponent civilian among members of the police, which may make them more likely to use force. In simpler terms, a maligned image is framed and the actions that follow are highly consequential, which is dangerous and just not right. This directly results in an indirect causal relationship between social distrust and police violence through armed violent criminal acts. One of the noticeable traits regarding the death of George Floyd was the barbarism and unprofessionalism of police action taken. The police officer in action, Derek Chauvin, was kneeling for 8 minutes and 46 seconds on the arrested person who died consequently. The case of Eric Garner, mentioned earlier, is very different from the one in discussion because the person involved was alive when he was taken to the hospital. The cause of his death was never really investigated, and thus it is not clear in what capacity the law enforcement was to be blamed and what the police had to do with his death. Floyd lost his life on the spot in a reversal, and a connection between restraint and death was proven. This claim was further nurtured by the fact that the policeman involved was taken into custody in a mere span of 4 days. The time frame in which proceedings were launched because of a police officer taking illegitimate action and causing death was astronomical. Was this due to the abrupt movement that took shape, or was the evidence pretty much against the police force? The question partially remains. Another factor that needs to be taken into account is the nature of the offense, which led to the casualty, and his behavior provoking police violence cannot be ignored. The world needs to be taken into consideration again and again. In this case, the behavior was that the offense which provoked the police to take action was a counterfeit $20 bill, which the victim tried to pay in a store. This shows that the police action was not in response to a severe violent crime and cannot be left as a mere coincidence, considering that this aspect was emphasized in reports by most media outlets like the New York Post, the Daily Mail, and the BBC. Furthermore, the victim was also unarmed, thus raising more questions about the legitimacy of the act. All these cases and statistics related to the George Floyd case highlight the ongoing struggle between law enforcement and the African American community due to internalized societal racism and incorrect police training. This struggle led to movements such as Black Lives Matter and Defund the Police, which were both outcries from the African American community to bring attention to this blatantly open racist treatment of African American youth. These modern-day revolutionary movements are necessary as they highlight fatal laws in the law enforcement training system. Recent statistics show that Black people are more than 2.5 times as likely to be killed by the police than white Americans, and all the social scientists and preachers of law collectively agree that the primary responsibility when a police officer takes another person's life solely lies with that officer and the institution of law enforcement. These morbid and deadly encounters have led to continuous cries for police reform. In 2018, the New York Police Department began a program for implicit bias training, which caused a butterfly effect for various other police departments across the U.S. One of the most effective ways to help communities hire better police officers is personality psychology. Center for Policing Equity, in its 2019 report, stated, "Unlike clinical assessments that are used to diagnose personality disorders, modern personality assessments are used to predict everyday work behavior, how effectively people do their jobs, and how people respond under stress. These assessments can promote diversity and inclusion by providing an unbiased view of the candidates fit to serve as a law enforcement officer." If the great Martin Luther King Jr. was still alive, and if in his presence a white man had brutally murdered a black man, he would have also made statements that every effort the black man or woman puts into fighting for freedom will always be met with backlash. He would have told us all that we should work together to achieve his dream of one day being equal. But the fact is that people have already tried and have discovered that people of this nation only respond to a humongous spectacle. People will always have the central point of living together in harmony with diplomacy, but no one was talking about the murder of George Floyd till people took to the streets with their voices and hands in the air. The narrative drawn against the protesters is of unnecessary violence. If this is true, every individual who has lost their life under the circumstances similar to these must be asked to compromise and taught that this is the way of things in the most progressive nation in the world. Any sane mind would say otherwise, so the revolution sparks and will continue until the equality in all spheres is achieved. The sad state of affairs in the age of social media is that people have short-term memory and even shorter attention spans regarding political and cultural issues. They usually last for a week or so until more sensational Kardashian photoshoot drops. Talk about priorities. Although there has been a sudden spike of interest in the conversation about the oppression of African American communities in America, this is just not enough. The primary question arises: what world do we live in? The nation built with the blood and sweat of its inhabitants now plots revenge against the same people. This must stop. It has been said for quite some time now for the oppressed that we are oppressed, we are exploited, we are downtrodden, we are denied not only civil rights, but also human rights. So the only way we will get some of this oppression and exploitation away is if we come together against the common enemy. From the common man's perspective, the court of justice seems to be a field where there is always a winner and a loser. This means that the two engaging sides come to a conclusion in the sense that one is sentenced for a particular crime while the other side is proven innocent. Well, this is a misconception. The reality is mind-boggling. While the majority of the population views the resolution of criminal charges in the US justice system in the form of a jury trial, but the reality is that more than 94% of successfully prosecuted state criminal cases and 97% of federal criminal cases end in plea bargains. This means that a humongous number of criminal cases in the US never go to trial at all. Sounds interesting, right? Let's start with what this is all about. A plea bargain is a mutual agreement between a prosecutor and a defendant that depends upon the defendant pleading guilty to some or all charges in an engaging case. Defendants are often advised by their counsel to accept the terms of a plea bargain if they seem beneficial to the defendant compared to continuing the case further. The defense counsel here can be a public defender or private attorney hired by the defendant. The main point is that for the two sides to strike an agreement, both have to see a benefit in the plea bargain. Sounds very natural, doesn't it? Prosecutors, on the one hand, are interested in getting a guilty plea and an efficient resolution to the case, while defendants, on the other side, are encouraged to plead guilty to receive a reduced or less harsh sentence. This basic definition and scenario of plea bargains makes the concept sound reasonable, considering that both sides can see something for themselves and reach a common ground for execution. The problems arise in the execution of this concept, which is, in turn, dependent on deeply uneven power dynamics, race and class position of defendants. These factors often force the defendants to accept an uneven and unfair sentence and thus make the outcomes unfavorable to them. These mechanisms are meant to free courts of excessive cases that seem to go nowhere, but the execution of plea bargains does not always align. Critics argue that plea bargains lead to coerced guilty pleas and provide cover for corrupt or unlawful behavior on the part of prosecutors. This is the common argument that is related to the simple judicial process. What makes it diabolical are the dynamics attached to them. Sufficient evidence has been collected in recent years, pointing clearly to significantly different outcomes for white and black defendants in plea deals, particularly for those without prior convictions. In such deals, prosecutors are free to determine both the initial charges and whether or not the charges are reduced or dropped during negotiations. This naturally grants them extra power, even more than the presiding judges, in determining the sentencing of defendants in these cases. Sadly, racial biases play a big role in how prosecutors determine these charges. Primary statistics and studies of over 30,000 cases in Wisconsin showed that white defendants were 25% more likely than black defendants to have their most serious initial charge dropped or reduced. In contrast, black defendants were more likely to be convicted for the same case. Adding to this, for defendants that involved no prior convictions, white defendants were over 25% more likely to receive a reduced charge during plea bargaining than black defendants. The Wisconsin study showed an even higher divergence between outcomes for white and black defendants in misdemeanor cases. White defendants were almost 75% more likely than black defendants to have all charges associated with imprisonment dropped. These studies show the inclusion of a deep-rooted racist association of the black community to relate them with crime and anarchy automatically. This is what implicit bias looks like, as discussed in previous episodes. This phenomenon is further fueled by the inclusion of the socioeconomic status of the defendants and the prosecutors, which also play a huge role in plea bargaining. Quite naturally, defendants with sustainable and equitable financial resources can afford to pay for a private attorney who can carefully take forward these plea deals, or in other instances, guide their client to demand a trial in favorable cases. This is not true for financially inefficient defendants, where private legal help is not an option. This, in turn, makes them dependent on public defenders, who are often already overburdened with cases and provided with few resources to give their clients the best possible representation. This is complemented by a shortage of court time, and the bargains can often be deemed a harsh compromise for one side. Capital and racial disparity shouldn't be a hurdle in the deliverance of justice. It is not hidden that the American criminal justice system disproportionately targets black adults, with their incarceration rates approximately 5 to 7 times higher than their white counterparts, as noted by a 2016 study conducted by B.L. Kutatiladze and B.D. Johnson. Research suggests that these incarceration disparities are not solely due to discrepancies in arrest rates, but are affected by the plea bargaining process between arrest and incarceration. There is limited research exploring the plea bargaining process, and even fewer studies investigating how mental processes such as implicit bias affect defense attorneys and prosecutors' decisions to offer plea bargains. However, current research suggests that defense attorneys negotiate more severe plea bargains for their minority clients due to the impact of implicit racial biases on their decision-making processes, resulting in higher rates of criminal pleas with fewer charge reductions and more prison time for black defendants. Effective study on these topics and implicit biases that affect plea bargain offers have the potential to lead to improvements in how a defendant's case is reviewed and inform recommendations for mandated sensitivity and bias training for legal officials, as noted by T. Eisenberg and Lynn Johnson in their 2003 published paper. Future research must be done to explore how factors such as criminal records, a lack of private counsel, and socioeconomic status may affect a black individual's plea options compared to their white counterparts, especially since early research has indicated that these extralegal factors have a strong influence on minority overrepresentation in rates of incarceration. The main point to be noticed here is how lack of funds and other resources deprive people of a fair chance in court, which is then complemented by preconceived notions not only among common folks, but in the minds of reputed judges as well. In the upcoming episode, we will explore the next element in this process, i.e., sentencing. We will discuss how factors such as racial segregation impact the severity of any sentence for people belonging to the Black community or any other ethnic minority group. Stay tuned for more. It is a fact that the United States criminal justice system is the largest in the world. If we look at literal figures, at the end of 2015, more than 6.7 million individuals were under correctional control, including 2.2 million people incarcerated in federal, state, or local prisons and jails. This is an infamous figure, but the US is the world leader in its incarceration rate. Such broad statistics really don't display the racial disparity that invades the justice and law institutions in the US, and for African Americans in particular. It must be noted that African Americans are more likely than white Americans to be arrested. And once arrested, they are more likely to be convicted, and once convicted, they are more likely to experience lengthy prison sentences. Some reports suggest that African American adults are 5 times as likely to be incarcerated than whites, and Hispanics are 3.1 times as likely. As of 2011, 1 of every 3 Black boys born in that year could expect to go to prison in his lifetime, as could 1 of every 6 Latinos, compared to 1 of every 17 white boys. This doesn't mean that individuals from the Black community are always up to something. When we talk about an issue, a range of factors have to be taken into account. Privilege is real, folks. This data also reflects the justice system's attitude as having a bias towards a particular ethnic group, as discussed before. It shows just how deeply this has penetrated the consciousness of society as a whole. Racial and ethnic disparities among women are less substantial than men, but remain prevalent. The source of these disparities is often not coincidental, but deeper and more systematic than explicit racial discrimination. It seems that the United States operates 2 distinct criminal justice systems. One for the wealthy, privileged, and socially better placed people, and another for poor people and people of color. It is quite natural that these wealthy folks can access a comprehensive adversary system with constitutional protections for defendants, which makes them better equipped to face the consequences of anything they do. On the other hand, the experiences of poor and minority defendants within the criminal justice system are often harsh, and they find it substantially difficult to keep up in the same playing field. As anyone would tell you, these double standards are not explicit. On the face of it, criminal law, in theory, is colorblind and class-blind. But in a wider sense, this only makes the problem worse. The rhetoric of criminal justice systems sends the message that our society carefully protects everyone's constitutional rights. Still, in practice, the rules assure that the law enforcement process will generally serve the poor and will prevail over the rights of minorities and the poor. This proves right and can be clearly seen in statistics related to sentencing. Although African Americans and Latinos comprise only 29% of the U.S. population, they make up 57% of the U.S. prison population. This results in imprisonment rates for African American and Hispanic adults that are 5.9 and 3.1 times the rate for white adults, respectively, and at far higher levels in some states. Notably, these disparities exist for both the least and most serious offenses. This also means that for a particular crime, they are given sentences far more terrible than the rest of the population. Of the 277,000 people imprisoned nationwide for a drug offense, over half, 56%, are African American or Latino. Nearly half, 48%, of the 206,000 people serving life and virtual life prison sentences are African American, and another 15% are Latino. 48% of the approximately 206,000 individuals serving life and virtual life sentences are African American, and 15% are Latino, as published in the Sentencing Project in 2018. In states like Alabama, Illinois, Georgia, Maryland, and South Carolina, 2/3 or more of individuals serving life and virtual life sentences are African American, again reported by Sentencing Project in 2017. Over half, 56.4%, of those serving life without parole sentences are Black, 33.5% are white, and 7.4% are Hispanic, as reported by the Prison Policy Initiative in 2016. 80.4% of life and virtual life sentenced youth are people of color. 55.2% are African American. The racial disparities in the adult and juvenile justice system result from policing and pretrial factors described earlier, and are complemented further by discretionary and racist decisions. These sentencing policies disadvantage people of color because of their race or higher rates of socioeconomic disadvantage. This is truly baffling. Biased use of discretion. Prosecutors are likelier to charge people of color with crimes that carry heavier sentences than whites. In this regard, the example of federal prosecutors can be taken where they are twice as likely to charge African Americans with offenses that carry a mandatory minimum sentence than their white counterparts. State prosecutors also follow the same pursuit. Policies that disadvantage poor people. Most jurisdictions inadequately fund their public defenders who are responsible for the majority of poor citizens and their cases. While there are many high-quality public defender offices, in far too many cases, indigent individuals are represented by public defenders with excessively high caseloads or by assigned counsel with limited experience in criminal defense. Some key findings have been prevalent in understanding the vivid difference in the law system for different people. It is widely considered that Blacks pay a relatively higher trial penalty than comparable white counterparts. Whites are granted a larger reduction in sentence time than Blacks and Latinos on the grounds of providing substantial assistance to the prosecution. Blacks are more likely to be jailed, and their trials are thrown into the inevitable realm of pending cases more often than whites. They also tend to receive harsher sentences. This also rings true for capital punishment. In most cases, the victim's race tends to impact the sentencing outcome, with a proportion of Black victim cases more often resulting in death penalty. The combined impacts of biased policing, discretionary charging decisions, and sentencing enhancements have created and nourished a criminal legal system in which people of color, particularly Black people, are more likely to be sentenced to prison and are subject to lengthier periods of incarceration. These policies need a definite revamp, and a more just system is the need of the hour. Stay tuned for the next episode. In this episode, we are going to discuss an important aspect of the criminal justice system that is not only native to the United States, but various countries around the world. This aims to describe how the current bail system in America is discriminatory and unjust for people of color, including the Black community and many other ethnic groups. The American criminal justice system is represented as a system run by procedural justice, which focuses on how the police and other law authorities interact with people and the opinion forged in the public's mind regarding the authorities. This makes government officials genuinely concerned about the fairness and transparency of the process by which decisions are made. This automatically presumes that every American will be treated with the same respect and dignity, and that they will be given the same opportunities regardless of their socioeconomic status and racial or ethnic backgrounds. However, America's cash bail system and its impact on certain sections of society is not the same. The reality is that it is highly discriminatory and can be compared to an evil and institutionalized capital system. Considering the monetary funds required to avail the basic right of bail. While this runs true for every citizen, its impact is felt most crucially by the Black community. This disheartening reality is that the Black community doesn't receive the same treatment as other Americans from the start of the criminal justice journey. We have discussed so far that they are more likely to be under surveillance by police, pulled over, searched, charged with an offense, lack proper representation in court, less likely to get a plea deal, and more likely to receive a harsher sentence. All odds are stacked against them. This leads to a poor experience between these people and the criminal justice system, creating a cycle of miscommunication and maltreatment between both parties. This troubled relationship is why there has been an upsurge in substantial reform in the criminal justice system. Among these, the present bail system is a big contributing factor to the discrimination that individuals from the Black community are subjected to. This sphere needs immediate reform. It is an immense problem that, once dealt with, will help to eliminate various other issues within the current criminal justice system. Bail is considered a conditional release of a defendant with the promise to appear in court whenever required for proceedings. It is a set of pretrial restrictions imposed on suspects to ensure they will not tarnish the judicial process. Currently, there are 5 types of release mechanisms: release on recognizance, release on a citation, cash bail, property bond, and secure bond. The point of discussion here has to be cash bail. Cash bail is a process in which the defendant pays a set amount of money to be released from custody. This amount of money can vary regarding the nature of the trial being undertaken. It can vary from $500 to as high as millions of dollars. The amount of money to become bail is set by the judge appointed to the case. Cash bail was started as a method to free untried prisoners while they awaited future court appearances, and was done in order to have them appear in court at a later time when necessary. However, this practice, which was once introduced for the betterment, has now become controversial, and its motive isn't being fulfilled. This is said because the truth is that cash bail no longer represents untried prisoners, and in contrast, has become an immense burden on low-income defendants. This new bail system clearly favors the wealthy and punishes the poor. Despite the countless issues regarding cash bail, it remains the primary mechanism for defendants to obtain pretrial release nationwide. Over the last several years, Black Lives Matter activists have grown collective action around criminal justice reform, more recently in response to the murder of 46-year-old George Floyd, a Black man in Minneapolis, Minnesota. Floyd was fatally suffocated by the aggressive and inhumane tactics Officer Chauvin used. Thousands across the country mobilized, demanding justice for Floyd. Yet Officer Chauvin was still able to pay bail and was released from custody. Chauvin had just been arrested and charged with second-degree murder for the wrongful death of Floyd, and through donations, he was able to pay his bail, which was set at an enormous amount of $1 million. If an innocent person of color is forced to sit in jail and await trial, when, on the other hand, a guilty white man can walk out of jail after paying $1 million, proves that there is an issue when dealing with the bail system. Hundreds of thousands of people are working inside and outside of the system for reform. As a result, states vary in their use of cash bail systems. Oregon, Illinois, Kentucky, and Wisconsin approach bail in different ways. For example, one can be released in Oregon by paying 10% of their set bail. Kentucky banned cash bail 40 years ago. Instead of imposing a cash bail amount to decide who gets to go home, they decide to use a risk assessment tool statewide. California is working towards getting rid of the cash bail system entirely and has decided to do pre-trial risk assessments to categorize suspects of low, medium, and high risk to help the judge decide if the individual is safe to go home and does not pose a threat to society. However, while some states are actively working to reform the cash bail system, the remaining states face immense pressure from people of color to change this unjust system. Another factor that many ignore is that keeping suspects in jail if they cannot afford cash bail is bad for their health. A well-documented body of research describes the negative health outcomes directly associated with and whose risk is increased by incarceration. This includes higher rates of HIV, hepatitis C, and tuberculosis. Incarcerated individuals also have a higher likelihood of chronic illnesses like hypertension, asthma, arthritis, and cervical cancer, as well as mental health issues such as anxiety, depression, and schizophrenia. The point that must be noted in this regard is that Black Americans often have disproportionately high rates of chronic and infectious diseases because of other social factors. These conditions are compounded by the impact of the prison environment, poor quality health care in correctional facilities, and the fallout after release from incarceration, such as lack of access to housing and jobs and a high rate of poverty. And this is just the first layer of all that really happens on the ground. Jails often rely on secured bail money as revenue, creating an indirect stream of incentive for police officers to make arrests. However, communities have to pay for more than they actually deserve. Research has shown that even short pre-trial detention of 2 to 3 days may negatively affect court appearance, conviction, sentencing, and future involvement with the criminal justice system. And when the Black community already faces a million problems in dealing with the court system, a bad reputation and inability to continue the case is not a thing they wish to do. Even after every incentive, the system is expensive. According to a report, pre-trial bonds alone cost local governments and taxpayers an estimated $13.6 billion annually. Providing health care in jails is difficult and expensive, and often is paid for by other local agencies. The employability and socioeconomic conditions of certain communities must be considered in exploring the comprehensive ill effect of this system on them. It is a known fact that Black and Hispanic men are less likely to be employed than white men due to their already existing notions regarding their background. Many of these families depend on the little money the man of the household brings in, and when these men are arrested and cannot afford to make bail, they end up being incarcerated and losing more than just their freedom. They lose their livelihood and an entire family that is destroyed. Other members are forced to live below the poverty line. Many of those children with incarcerated parents are forced to start working and leave their education behind. The most unfortunate case is that one or the other member falls victim to the same cycle that took their loved one. The cycle doesn't stop here as well. When these men and women are released from jail, they find it more difficult to get jobs and housing, which further puts them at a disadvantage, and they make the same mistakes over again, resulting in the endless cycle that has been happening for hundreds of years. So to prevent this, judges should implement the use of personalized diversion programs instead of jail time. The cash bail system must be eradicated, and some other form of guarantee must be the norm to prevent this type of segregation. The criminal justice system is not a business, and social and economic disparities must be abolished. Jail should be a place where people have an opportunity to repair the harm they have done, and that too, if needed, they are guilty of a crime in the first place. Jail should not be a place to profit from underprivileged people and should not be a playing ground for the rich. Changing the cash bill system is one step in a better direction and can play a role in including various people from varied backgrounds. Everyone deserves a fair shot at justice. In the coming segment, we will move away to witness these stories and instances on the big screen. A barrage of movies and TV shows over the years has captured the hatred and segregation towards the Black community regarding the judicial system. Let's see what they say to us. It is often said that the most artistic and real method of representing misery is by employing those mishappenings, or for that matter, any event that we have only heard. Cinema and the silver screen does just that. With familiar faces and a mainstream appeal, streaming services have been putting great emphasis on real-life events and have helped them to reach a wider audience over the years. We have witnessed Hollywood classics over the years that highlight racism, segregation, and slavery, such as 12 Years a Slave, Malcolm X, The Glass Shield, Fruitvale Station, and many more. But this particular segment is intended for an even greater emphasis on misconduct that is closely linked to judicial machinery in particular. The American criminal justice system has now been long infamous for brutal policing, unethical prosecution, and incarceration, and it is worthy to note that these elements just didn't pop out of thin air. The institutions that are tasked with keeping order are the products of a long series of choices and policies. And behind those choices and policies are specific ways of thinking about who deserves justice, who is guilty, and what the purpose of law even is, all of which derive from America's past. In order to understand these themes with a better viewpoint, police brutality, punitive and unequal meting out of justice, demonstrable racial prejudice, and a broken prison system, then these films and TV series are something you must go through. Through fiction and non-fiction, they show how complex the interlocking problems are and point toward where true change might begin. 13th, 2016. A thrilling and engaging experience. 13th, from director Ava DuVernay, is a prime analysis of the historical context and moral urgency behind many of today's most prominent public issues that range from unlawful incarceration to the war on drugs and police brutality. It also explores the motivations behind the Black Lives Matter movement that took the nation by storm. This documentary is a compelling tale of America's long history of racism, and more importantly, it's a fact check on America's long history of actual denying its reality of racism and the ways that its denial has affected the country's justice system. Clemency, 2019. This story is about Bernadine Williams, Alfre Woodard, who has spent years working as a warden at a maximum security prison. It has most clearly been affecting her health, which later creeps into her marriage and even her own soul. She has formulated a rule for herself to find meaning in her work, which involves taking care of the inmates and quietly supporting them as they approach their execution dates and final destinations. But then a lethal injection goes downwards unexpectedly, and as the date for the next one approaches, she finds herself reaching a breaking point. Director Chinonye Chukwu crafts a heavy, deliberate film with rich, widely framed shots and dark colors that take an emotional toll on not just Williams, but also her co-workers, their families, and the inmates. It has been carried by an absolutely stunning performance from Woodard. It's an unusual way to expose the injustices of the capital punishment system without forgetting the individuals stuck in its rafters. Crime plus Punishment, 2018. The common habit of policing, which is based on quotas, requiring officers to arrest a minimum number of people within a particular time frame, as if to complete a quota of tomatoes on any given evening, was outlawed in New York City in the year 2010. This practice was questioned and was seen in a way in which police officers were moving away from doing their job to maintain order and serve the community and themselves, finding ways to eliminate violence before it happened. Officers would make arrests just to hit their numbers, as if to complete sale targets in any marketing firm. Only that the target here was humans, and not any virtual commodity. The thing to notice here is that those arrests often happen disproportionately in low-income minority communities. As mentioned before, outlawing these quotas didn't do any good but worsen the condition. With the help of interviews, secretly recorded conversations, and other footage shot from 2014 to 2017, Stephen Meng's documentary, Crime plus Punishment, explores the NYPD's ongoing but concealed use of quotas and their effects on the citizens of New York, particularly the Black community and officers in the police department as well. The Innocence Files, 2020. The Innocence Project is an idea institution founded in 1992 by law professors Barry Scheck and Peter Neufeld, devoted to overturning wrongful convictions by using DNA evidence to free innocent prisoners while also advocating for reform in the criminal justice system. Netflix made a documentary by the same name and presented stories of some of the people they've helped over the years. The documentary spans 9 episodes, some being as long as a feature film. It drew on the same intriguing cases that are converted to a branched and comprehensive true crime series while also illustrating the breakdown of supposedly fair systems and the unreliability of certain evidence that seems true otherwise. It is perhaps one of the best of its kind. Just Mercy, 2019. The American practice of capital punishment pretty much summarizes what is wrong with the justice system. It focuses on extremely harsh methods rather than therapeutic constructive solutions. It has an unfair bias against the poor, mentally ill, and marginalized due to their inability to properly represent themselves in a trial, which is then heightened by a scope of racial segregation. This is what Just Mercy is, a true story that makes the audience change their sense of injustice and reframe it. It is based on Bryan Stevenson's best-selling 2014 memoir of the same name. It tells the story of Stevenson's early career as an attorney working to reverse wrongful convictions in the state of Alabama, and gives crucial information related to the foundation of his organization, known as the Equal Justice Initiative. Just Mercy isn't a normal script about the mechanism of the death penalty. It's also about how old attitudes toward the poor and Black Americans in particular have played out in the American justice system. It aims to change our perspective, how we think about capital punishment, and what the justice system must do to fulfill its purpose truly. Whose Streets, 2017. The co-directors of Whose Streets are Damon Davis and Saba Folayan, who are on the inside of the protests following the 2014 killing of 18-year-old Mike Brown and the birth of the Black Lives Matter movement. It's a raw piece of work from footage and interviews presenting an unabashed, brutal perspective and connection to the activists. The film opened in theaters in 2017 as a white supremacist march began to unfold in Charlottesville, Virginia, and it's no less relevant today. It's an essential piece of historical documentation that needs to be witnessed in its entirety. The Central Park 5, 2012. This widely acclaimed film examines the mind-boggling story of 5 Black and Latin American teenagers wrongly convicted of the rape of a white woman. With sentences ranging from 6 to 13 years, the men were eventually freed thanks to DNA evidence. The story is proof of the ruthless cycle of racial injustice, poverty, and a biased, broken system. Throughout this journey, we listen to perspectives and events that have contributed to the increase in racial segregation and discrimination since the dawn of colonialism to its present-day bias, which still creeps within the soul of every second white man. This kind of hate and impulse isn't restricted to everyday notions of society, but has made its way to the holy floors of judicial courtrooms. We have been taught to see justice as an empowering mechanism that protects the liberty and livelihood of every living being on God's green earth. But as it is said, reality is often disappointing. How can a Black man breathe the same air as others without paying the price for it? This isn't a sensational claim in the fury of words, but it's the practical reality of things. From the infamous Jim Crow laws to the notorious slavery system, from the evils faced by Black defendants in a literal white man's court, things have only been as dark as they can be. Recent statistics and findings have created a subtle impact, but it's not enough to change a mindset that has been vigorously programmed to cater to a few individuals' needs. A social revolution of gargantuan proportion can only bring about real change. It is the only way. I hope you got a better perspective with this special episodic series dedicated to a just cause.